Not talking yet.
The judge is out. It's like his network is not too good. The judge.
He's talking.
No, he's like he's not. He doesn't need the meeting now. He's trying to sort out his network.
Don't open it. Still talking.
The network has been bad. It seems to be back now. So this is the ruling. Omoge, are you there?
As God pleases, my lord.
As God pleases, my lord.
That is how it is done so that the court knows we are together, whether on Zoom or you are before the court. That is the tradition. Thank you. Ruling. On the 5th September 2022, engineer Dr. Olubayode Smart Adeleye took out an originating summons against the defendants, praying for the following. 1, a declaration that the termination of the appointment of the claimant by the defendants is wrongful, unfair, illegal, and void. 2, an order setting aside the termination of the claimant's appointment from his employment and the withholding of his salaries by the first defendant as same is wrongful. An order directing defendants to reinstate the claimant to his appointment, pay salaries of the claimant from the date of his unlawful termination of employment till the date of judgment and thereafter. An order of perpetual injunction restraining the defendants, whether by themselves, their agents, or previous, from discipling. And I put sick because it should, I guess it should be disciplining or terminating the appointment of the claimant without compliance with his conditions of employment and the procedures for fair hearing. On 5th March 2024, when the case came up for hearing, Lanet Omoge Esquire of counsel for the claimant informed the court that the claimant is deceased. On the 9th May 2024, on the 9th May 2024, the claimant counsel filed this motion praying as follows. 1, an order granting leave to the interested parties / applicants to be substituted as the claimants in this suit, the original claimant having died. 2, an order granting leave to the applicants to amend the complaint and the statement of facts as shown in the proposed amended complaint and proposed statement of facts. 3, an order deeming the proposed amended complaint and proposed statement of facts as being properly filed and served. affidavit in support of motion. In a 10-paragraph affidavit deposited by one Ayobami Orojimi, a litigation manager in the firm of Banjo Ayena Kin and Co., it is the position that Mrs. Olubayode Olayinka informed me, and I verily believe her, as follows. 1, the claimant was one of the parties in this suit. 2, the claimant died in February 2024. 3, consequent upon the demise of the claimant, it is necessary that the name of the claimant be changed and the name of Mrs. Olubayode Olayinka Abiodun and Ms. Olubayode Joy Oluwafumilayo be substituted for that of the claimant. 4, the first applicant is the statutorily married wife of the deceased claimant, while the second applicant is the only daughter of the claimant. 5, the applicants are the beneficiaries of the estate of the deceased. 6, okay, that the cause of action is such that can survive the deceased. Written address in support of the motion. The applicant's counsel formulated a single issue for determination as whether by virtue of the affidavit evidence placed before this court, the applicants are not entitled to the relief sought in the motion paper. Counsel answered in the affirmative and submitted that the cause of action is such that survives the claimant. The main reason for amendment here is to put the pleading in such a manner that the death of the deceased will permit the applicants to continue this matter. He cited Nkoro versus Azuru. Citations supplied. First respondent's counter affidavit. One Joseph Augustine Otabi, the litigation secretary in the law firm of Ahmed Yusuf and Associates, deposed to a 19-paragraph counter affidavit for the first defendant respondent. 1909. Sometimes some of these things, they just sound like they don't add up. 19. Yes. A 19-paragraph counter affidavit for the first defendant respondent. It is his position that facts constituting the grounds of the interested parties applicant's purported motion on notice are slanted and misleading, that the first defendant deemed it fit to file the instant counter affidavit to show that the instant action is a personal action that terminates with the demise of the original claimant, that by virtue of the action instituted and the principal relief sought by the claimant, the nature of the rights which the claimant seeks to enforce is of a personal nature and cannot be transferred to any other person who has no employment/contractual relationship with the respondents. That I know as a fact that the determination of the legality of the employment of the claimant herein cannot be a subject of succession, and the employment of the claimant cannot be inherited by any of the interested parties applicants. That this honorable court is here to determine the instant suit and grant the relief sought therein before the claimant's demise, and all the relief sought in this action are personal to the claimant and cannot be enforced or exercised by the interested parties applicants. That contrary to paragraphs 5, 6, and 7 of the affidavit in support, I know as a fact that there is no basis to file an amended complaint and statement of facts in order to place and or substitute the name of the claimant with the names of the interested parties applicants. That I also know as a fact that based on the original processes filed by the claimant and the relief sought therein, the present suit cannot survive the claimant. First respondent's written address. The first respondents counsel in his written address formulated the loan issue for determination as whether in view of the nature of the instance suit and affidavit evidence placed before this honorable court, the applicants are entitled to the relief sought. That the facts and claims in the suit are personal rights of the claimant and cannot be transferred to any other person. That it is tried law that the personal right of action dies with the person. He cited Okonwa and Doherty citations supplied Alhaji Kasali Yakubu and others versus Alhaji Isiaka Bukola and other citations supplied. That the principles of law which states or outlines the circumstances where the death of a plaintiff or claimant during the pendency of an action does not abet the action are: one, whether the deceased sued in a representative capacity; two, whether the cause of action survives the deceased plaintiff; three, where, though the plaintiff did not sue in a representative capacity, but the pleadings and claims show conclusively a representative capacity. He cited Osaguna and military governor of Ekiti State. Citation supplied Aro Wolo versus Akapo. Citation supplied. The determination of the legality or otherwise of determination of the employment of the claimant cannot be a subject for succession, and the employment of the claimant cannot be inherited by any of the interested party applicant. Court's decision. The loan issue for determination, in my view, is whether in view of the facts and relief sought in the original suit, the suit survives the original claimant and can be inherited by his successors. The principle of substitution of a deceased party with the living was stated in Hadeja versus Ladan and others, 2017 LPLR 43368CA as follows. The position of the law is that the death of a plaintiff during the pendency of an action does not abet the action when the following exist: one, the deceased sued in a representative capacity; two, the cause of action survives the deceased plaintiff; three, though the plaintiff did not sue in a representative capacity, but the pleadings and claim show conclusively a representative capacity. See also Osaguna versus military governor of Ekiti State. Citations supplied Aro Wolo versus Akapo. Citations supplied. A cause of action survives a deceased plaintiff when the action is not personal. The maxim actio personalis moritori cum persona, meaning a personal action dies with the person, generally applies where the reliefs claimed by a deceased claimant are personal to him. In such a circumstance, the action cannot survive the deceased claimant, who will solely and personally be the beneficiary. See Momodu versus Momo, citation supplied. In Yakubu and others versus Bukola and others, the court held as follows. An application for substitution of a deceased party postulates that an action based on the personal rights of a deceased person survived and did not die with the deceased person. The essence of substitution is to give the substitute the same cause of action which the substituted party had at the date when the writ in the action was issued. See also Chief J.A. Sani and another versus Commissioner of Police, Edo State, citation supplied. Learned counsel for the applicant simply said in his written address, in a sentence, that the cause of action is such that survives the claimant. This is the almighty issue in this application, and I find it amazing that counsel will pay no attention to such. Learned counsel ought to state why the cause of action survives the deceased claimant and on what authority. Failure to do so is failure to carry out the duty imposed on him in a written address, which is to convince the court to see reason why the issue in contention should be resolved in favor of his client. This could often be disastrous. When looking at whether or not a cause of action survives a claimant, the court looks at the cause of action which the substituted claimant had at the date when the writ in the action was issued, not from the amended claim. A complaint or writ cannot be amended to survive a deceased claimant. The amended pleadings or claim or substitution has no role to play in the determination of whether or not the cause of action survives the deceased claimant, as suggested by applicant's counsel when he submitted as follows, and I quote, "The main reason for amendment here is to put the pleading in such a manner that the death of the deceased will permit the applicants to continue this matter." Accordingly, the reliefs at the time the suit was filed are as follows, and I reproduce them here again. A declaration that the termination of the appointment of the claimant by the defendants is wrongful, unfair, illegal, and void. An order setting aside the termination of the claimant's appointment from his employment and the withholding of his salaries for the first defendant as same is wrongful. 3, an order directing the defendants to reinstate the claimant to his employment, pay salaries of the claimant from the date of his unlawful termination of employment till the date of judgment and thereafter. An order of perpetual injunction restraining the defendants, whether by themselves, their agents, or privy, from discipline or terminating the appointment of the claimant without compliance with his condition of employment and the procedure for fair hearing. It is clear that all the reliefs are personal to the deceased claimant and none can be inherited by his successor. If the defendant was owing the claimant at the time of death, the claimants will become beneficiaries, but the right allegedly violated in the suit are personal. None of the applicants can be reinstated or made to inherit the job of the deceased claimant. They can only inherit what had already accrued to the deceased by law or right before his demise, which is transferable to his estate. In the amended claim, the applicants did not just amend to substitute the name of the claimant, but they also amended the reliefs without amending release 1 and 2 as follows. 1, a declaration that the termination of the appointment of the claimant by the defendants is wrongful, unfair, illegal, and void. 2, an order setting aside the termination of the claimant's appointment from his appointment and the withholding of his salaries by the first defendant as same is wrongful, unfair, illegal, and void. An order directing defendants to pay salaries of the claimant from the date of his unlawful termination of employment till the date of death. 4, a declaration that upon the exit of the late engineer Dr. Olubayode Smart Adeleye from the employment of the defendants, the deceased is entitled to exit entitlements and emoluments. An order directing the defendants to pay all exit entitlements and emoluments due to the late engineer Dr. Olubayode Smart Adeleye to the claimants who are beneficiaries of the estate of late engineer Dr. Olubayode Smart Adeleye. From the above, it can be seen that the original reliefs claimed by the deceased claimant are personal to the deceased claimant, and so the cause of action died with him. See Chief J.A. Sani and another versus Commissioner of Police, Edo State, and others, where the court held as follows: it is tried law that actions which are predicated on person's personal right to an action die with him. Only the newly introduced reliefs, 3, 4, and 5 are reliefs which the applicants can inherit, but unfortunately, from the case of Yakubu and others versus Bukola and others, citations supplied, It says the essence of substitution is to give the substitute the same cause of action which the substituted party had at the date when the action was issued. As at the date the complaint in the suit was issued, the applicants had not and could not inherit the cause of action and the relief sought. They could benefit from it only as long as the deceased claimant lived. I agree with the respondent's counsel, therefore, when he submitted that the cause of action was personal and it died with the deceased claimant and summarized as follows: the determination of the legality or otherwise of the termination of the employment of the claimant cannot be a subject for succession, and the employment of the claimant cannot be inherited by any of the interested party applicants. In the circumstance, the loan issue is resolved in favor of the respondents and against the applicants. The motion is accordingly dismissed, and suit number NICN/AK/29/2022 is hereby struck out on the demise of the claimant. This is the ruling of the court, and it is entered accordingly.
As called, please. Most grateful, my Lord.
I thank your lordship for the ruling.
Copies of the ruling will be ready for collection by tomorrow.
As called, please.
As God pleases.
Most grateful, my Lord.
Thank your lordship for the considered ruling.
Okay. IL 12-2023, Dr. Anthony Olayemi Ajiboye and Federal Civil Service Commission. Appearance?
Accomplices, my lord. The claimant respondent is also with us, sir. IK
Yes.
Kinyada
You can leave the meeting.
appear for claimant respondent.
Respectfully, my lord.
Because I can leave the meeting because your own case is.
Naeju.
Yeah, no, because this is another case.
Appearing with me is Ayako.
I didn't get your name. I didn't get your name.
Okay. D.O. Naeju, my lord.
D.O.
Naeju.
Yes.
Appearing with me is Ayako Abubakar, my lord.
So the commission will be represented by Musa.
For the
defendant, and also, my lord, the commission is the defendant is represented.
Please, this matter is for what today?
My lord,
My lord,
it
the
is
matter
for
is for the hearing of the pending applications of the dependent respondent, dependent applicant.
My lord, with the kind permission, my lord.
Yes.
With the kind permission of the court, Abubakar Yaku will continue with the proceeding on behalf of the defendant, my lord.
Yes, my lord, we have 4 different pending applications before the Honorable Court, sir. We have our motion dated 28 June, filed on same date, 2024.
Wait now.
Okay, sir, my lord, I'm sorry.
Iada,
Yes, my lord.
we have how many motions?
My lord, from my record there, I was served with 3 notice of primary objection and 2 other motions. All application making 3.
Iada,
Yes, my lord.
you are Iada, right?
Yes, my lord.
Okay, sorry. Sorry. Nayeru
Yes, my lord.
should be Abubakar now.
Yes, sir.
You
Yes,
have
my
how
lord.
many motions?
We have a motion on notice dated 28th of June,
You
2020.
have how many motions?
My lord, 3 and 1 counter affidavit. 3 and 1 counter affidavit.
1 counter of further affidavit.
Yes, a better and further affidavit.
We have 3 motions on notice.
Yes, and a better affidavit.
1, the first motion is dated
28th of June 2024.
28 what?
June 2024, my lord.
28 June 2024. Praying for
another for extension of time within which the defendant applicant may file their memorandum of appearance, affidavit, and other documents, statement of defense, witness statement on oath.
the second motion.
The second motion is talking about it's dated July 12th.
2024.
Yes, sir, my lord.
Praying for
a joinder, my lord. A joinder of Federal Ministry of Health and State House Clinic, my lord.
Okay. The third motion.
The third one is a PO, my lord.
Okay.
It's dated the 12th of July, 2024, my lord.
You have not stated the date of filing. Please, my very good friend and brother, in order not to confuse the noble courts, it's dated about file on 15 July.
My lord.
Yes, my lord.
Have you been served with all the processes?
My lord, I've been served with all the processes and have filed all the required response to all the applications, sir.
And you did what?
I filed response to each of the applications.
Please tell me. I don't like envelopes. We are already hearing. You file what?
My lord, thank you, my lord. My lord, I'm very sorry. My lord, in response to the motion of 28 June, I've filed my counter affidavit.
Counter affidavit. You are telling me you file response. What response is still an envelope?
Yes, my lord.
I usually don't like it here. Honestly, you say we have an application. It's an envelope. We file a response. It's an envelope. It can be a counter affidavit. It can be a written address in reply. It can be a statement of defense. All these are responses, isn't it?
I've copied this, my lord.
So you filed a counter affidavit to the first motion for extension of time.
Yes, my lord. Yes, my lord.
So you file counter affidavits
Yes,
in
together with the written agreement.
response.
Yes, my lord.
In response to all the motions.
Yes, my lord. I filed a counter affidavit 4th July 2024 to the first motion.
You also file a counter affidavit in response to the second motion.
My lord, I filed claimant written address on point of law only.
Okay.
On 24th July.
Then to the PO, you file a counter affidavit also or a written
My lord,
address?
written address on point of law on 24th July.
Okay.
Wait to my lord. My lord, I'm sorry for the interjection. I need to remind the court that the matter was already adjourned for judgment when they brought in all these applications. Great, my lord.
Okay, the matter was adjourned for judgment.
Yes, my lord. Yes, my lord.
The matter was adjourned for default judgment, my lord, in which we tried to regularize our processes. It was adjourned for default judgment, which we have done the needful, my lord.
Let me see. On the 14th of May, 2023, you said that
2024, my lord.
Iada said that is all for the witness. We asked for a date for continuation of hearing because we are bringing a witness on subpoena. Court, case adjourned to 10th June 2024 for hearing. Defendant is to be served hearing notice. That was what happened on the 14th of May 2023.
2024, my lord.
2024. Then on that 10th of June 2024, Iada, today is for continuation of hearing. Court witness is reminded of his oath of 14th May 2023. Iada, witness, and that is the case. Iada, that is all for the witness. That is all for the witness, and that is the case of the claimant. The court issued a subpoena on the Federal Ministry of Health. The response of the Federal Ministry of Health is here. The representative of Federal Ministry of Health is here in court by name Dr. Okpako. Forgive my pronunciation. Okpako. I have the document here with me, but it is not yet certified. And in the circumstance and Even by order, going by order 9.651, we ask for judgment. We drop the subpoenaed witness. Court case adjourned to 23rd July 2024 for judgment by Zoom. Defendant to be served hearing notice. On that, okay, 2nd July, sorry. You see, this one that somebody will give date, then you will come and say, no, it's not good before we say. So it's 2nd, not 23rd. On that 2nd July, Ianda for the claimant and Yaku Abubakar for the defendant. Claimant online and Yaku, we have a motion for enlargement of time to file our memorandum of appearance, statement of defense, etc. The processes are filed on 28 June 2024. Okay, so that is the motion we are talking about here, isn't it?
Yes, my lord.
The first one. 1 of June. June 2024. Okay. Okay, move your motion.
Yes. My lord, we are grateful, my lord. We have a motion on notice dated 28th of June, filed on same date, my lord.
My lord, sorry. My lord, sorry. Mr. My lord, sorry. My lord, I have an observation. We have to start with notice of prayer objection, sir. That is my humble view, sir. I see.
All right, you can come here and take over the seat and direct
my lord,
me how we conduct.
My lord, I'm sincerely
You
very
can
sorry.
come here, take over the seat and direct me how to take my proceedings.
My lord, I'm sincerely very sorry.
I have directed what is to be done, and you are saying, sorry, we have to. What do you mean by that?
No, my lord, I'm sincerely very sorry. I'm sincerely very sorry. My lord, I'm sincerely very sorry. In my humble view, I thought, and my lord, I'm sorry.
How do we even start with your preliminary objection when you have not yet even come in? The man is saying you should not even be allowed in, and you are saying we have to start with preliminary objection.
My lord,
and in any case, is it for you to direct?
My lord, I'm the one talking. I'm sincerely very sorry. My lord, I'm sincerely very sorry. My lord, I'm sincerely very sorry. I'm sincerely very sorry. I'm sincerely very sorry.
Abubakar.
Yes, my lord.
Move your motion.
Yes, my lord. As I've stated, our motion is dated 28th of June, filed on same day, and praying for 4 orders as stated on the face of the motion paper. My lord, we have about 5 grants on which the application was brought. We also have a affidavit in support of our motion. It's deposed by one Musa Ali. It's 5-paragraph affidavit. We are praying for the court and we rely on the paragraphs of the affidavit, my lord.
How many paragraph affidavit?
Yeah, more like 5-paragraph affidavit, my lord. Deposed by one Musa Ali. My lord, in line with the rules of the Honorable Court, we also have a written address in support of our application. We adopt same, my lord.
Iada was saying Iada is not even the one with the preliminary objection. Is he the one?
No, my lord, it's
My
that
lord, I'm not the one.
the PO.
My lord, I'm not the one. My lord, I'm not the one.
Okay. Yes.
My lord,
What are the reasons for this your delay?
My lord, our delay is based on the reorganization of us, because it was within that period the commission.
Based on what?
Based on briefing, and the commission new chairman was not appointed, and everything. The progress of government was delayed because the approval must come from the commission's chairman, and the briefing too was immediately, because this is a very old case, my lord. So those coupled with all these facts, it delayed the processes of we filing our let's say defense, and we need to file a competent and sincere defense. That is why it took us time, because of the briefing and that of the commission's reorganization, my lord.
Which paragraph? Because all this explanation you have given is even longer than the affidavit I have seen. So which paragraph of the affidavit? Your whole, this thing is delay in obtaining relevant information about the claimant from the relevant department of the defendant. That is the only reason I see here. But these reasons that you have given is even longer than the entire affidavit. So there was delay in obtaining relevant information on the claimant. Okay, that's all right. You adopt. Do you adopt? I will stop this Zoom something, honestly. All this faulty. Abubakar. 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 Iyada.
Yes, my lord, I'm here, sir.
I wonder, I just wrote for him, he adopts. So can we hear
Yes,
you?
my lord, our counter affidavit is filed on the 4th July 2024.
No, okay. Where the counter affidavit now?
Is accompanied.
You know they're supposed to follow the motion. Motion, then the counter affidavit. No, I mean the way you are supposed to arrange for me now, since you brought them up. Yes, what is the reason you are opposing?
My lord, they are binated for 9 months.
It is a 16 paragraph. It's a 16 paragraph counter affidavit.
Yes, my lord, very well. With exhibit
A paragraph is the crux of your opposition. Is for what reason that you are actually countering?
Yes, my lord.
Which paragraph?
My lord, I'm coming, sir. My lord, from paragraph, virtually from paragraph 2, because we have annexing exhibit, is from paragraph 2 to paragraph 14.
So I should read paragraph 2 to 14 to get a sense. Oh yeah, you summarize the paragraph 2 to 14.
My lord, I'm very grateful. All we are saying,
there has to be one paragraph that captures the crux. Not that we should read paragraph 2 to 14 before we capture the crux. You capture it for us.
My lord, I'm very, very
Yes.
sorry. Because we have a mixing exhibit, that is, you cannot rely on a single paragraph. We need to justify the reason why they must not come in, sir. My lord,
That is what I'm asking you. So what is your what is the reason why it should not come in?
my lord, they hibernated for more than 9 months. It was when the matter was adjourned for judgment. Audibly, they came to file processes.
He has been what?
Yeah, they hibernated. They went to slumber.
Okay, for more than 9 months.
More than 9 months, my lord. And at
Yes.
every adjournment, we are serving them hearing notices.
Yes.
And it's all these things that we exhibited, my lord. So they want to arrest
Yes.
the government of the Navy. So that is
So which authority says when you hibernate for that long, then you cannot come in
my lord,
as long as
my lord,
judgment has not yet been delivered? That even though
my
judgment
lord,
has not been delivered, you cannot come in because you have hibernated for long. Which authority?
my lord, I've cited new watch against attack. It's a 2006 Supreme Court. The rules of the court do not make provision for application to arrest judgment, which are about to be delivered by a court. An application not recognized as the rule of law cannot be described as a proper application. My lord, they are coming to arrest the judgment of the noble lord. That's what we are seeing, sir.
You say case of what?
New Watch Communication Limited versus Alhaji Aliyu Ibrahim Atta, 2006. It is contained on page 2 of our written address in support of the application.
I have seen it, but the man never asked to arrest any judgments. He simply asked for discretion of the court to allow him in.
And my lord, that is what happened in that case too. Exactly what they are asking for now is what happened in that case, sir. So I leave it to you. I leave it to the noble court.
My lord, we are very sorry. We're having some challenges just now with our network, and before I have issue, I will also have a further and better affidavit against the claimant respondent counter affidavit dated 4th of July, my lord. We are sorry, my lord. We are just because we filed our argument very well too. If
so, you file a further and better affidavit on what? You file a further and better affidavit on what date? Oh God.
My lord, is 15 July. 15 July 2024. I was served. As a minister in the temple of justice. I'm grateful for the indulgence.
This one that somebody is citing for me, rules of Court of Appeal. Okay. All right, I've taken notes.
Grateful, my lord.
Okay, sorry. So it is a 16-paragraph counter affidavit. Yeah, let's continue.
My lord, yes, my lord. No, my lord, is not it's 5-paragraph counter affidavit. Yeah, okay, my own. Okay, my lord, I'm
16.
sorry. My lord, my own is 16. I thought my lord is talking about their own, sir.
No, I have finished his own. I'm back to you.
Yes, my lord. My lord, 16 paragraph. My lord, 16 paragraph.
Yes.
I'm very grateful.
How many annexures?
My lord, A to F, my lord. A to F. A to F.
Annexures marked as
Exhibit A to F.
A to F.
Yes, my lord. Yes, my lord.
And in support,
we find a written address.
It's a written address.
My lord. in urging the noble court to refuse the application.
In support this written address.
Yes. And we
Yes, you
adopt it.
adopt.
Yes, my lord.
All right, thank you. Any adumbration?
No, my lord, our exhibit A to A, we are just trying to justify the reason why this application should be refused and nothing more. It's at the discretion of the court, and they have not done the needful, and we went ahead to demonstrate why the noble court should not grant the application. My lord, we are sincerely very grateful.
Good. In our motion, then. The main
My
motion.
lord. My lord.
Yes.
We my lord, we also filed a further and better affidavit.
You said so. It was taken on the 15th July, isn't it?
Yes, my lord.
I already took you down. And I
Okay,
saw
my
the
lord.
process also, yes.
Okay, my lord. Thank you, my lord. I'm grateful, my lord.
Come. Abubakar.
Yes, my lord.
In the same application that you are saying, I should give you extension of time to file your memorandum of appearance and statement of defense. In that same motion, you are asking me to strike out the suit.
My lord, we are sorry. It was just a mix-up, my lord. My lord, we are sorry.
Is that not incongruent?
My lord, we are sorry. We are sorry, my lord. We are sorry. It was a mix-up, my lord. We are sorry. We are sorry, my lord.
So what do you say about that prayer 3?
My lord, because we are talking about fair hearing, so the prayer 3 should be just, my lord, because we strike out for the meantime, pending when we go into the risk of substantive issue. My lord, for the meantime, since we have not dived into the main
what
issue,
do you want to do with your prayer 3?
We can strike out that.
Uh-huh.
Yeah, my lord, it should be struck out, my lord. My lord, we withdraw the prayer. Prayer 3,
I've recorded you already. I've recorded you. The application for extension of time though the case was adjourned for judgment, is one that can be granted in the interest of justice. The claimant can be compensated by cost. I grant the application and award cost of 100,000 naira in favor of the claimant to be paid on or before the next adjourned date, or the court shall invoke the provision of Order 38 Rule 4 of the rules of this court against the defendant. Thank you.
As a court pleases, my lord. We are grateful, my lord.
Yes. Now the next motion is the one for joinder.
Yes, my lord.
The defendant wants to join.
Yes, sir, my lord.
Claimant. 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 Iada. Iada.
My lord.
You should where is the motion for joinder? You should Federal Civil Service Commission, isn't it?
Yes, my lord.
And then the Federal Civil Service Commission is saying, I want to bring another defendant for you because the man also has a case to answer, not only me. Why are you objecting?
My lord, I will object, sir. The Federal Civil Service Commission.
Why are you objecting? It's not you will object.
Yeah, I want to tell my lord the reason why I'm objecting, sir. My lord, Federal Civil Service Commission is the employer of the claimant. He was one that issued. It was the claimant. It was one that issued all this letter we are talking about, the letter of dismissal, everything to the claimant.
Yes.
My lord.
Yes.
The Federal Ministry of Health is not a juristic person.
Who said?
Yes, my lord. Our paragraph 2.08 has already cleared that, sir.
Okay.
Our paragraph 2.08 is very clear on our that, sir.
All right. All right. The other motions shall be adjourned to January so that we'll attend to other matters in court for today.
As court pleases.
At least the defendant is in now.
Yes, my lord. We are grateful,
my lord, sir. My lord, sir.
Yes.
My lord, I want to plead. I want to plead with the noble court.
Yes.
I want to plead with the noble court. I know the workload is much, but if this motion can be had and the ruling is reserved, so we know it's out of it, sir. My lord, I'm pleading.
So I will go on Christmas break with a ruling on my head.
My
that
lord,
is your prayer for me.
My lord, I can understand.
That your ruling should be waking me up during Christmas break.
My lord, there's no problem, sir. When
we take this motion, can we rule this December? No, it has to be January, isn't it?
As
please, my lord.
So let it not disturb my holidays. I have not seen my family for 3 months. Then the only 2 weeks that I have to see them, you want your own ruling to be disturbing me. I will resist it.
As God pleases, my lord.
My lord,
I only take the ones I can now.
I trust my lord, but the judgment of my lord supersedes every other person. My lord is very hardworking, which I know.
Thank you.
My lord. Yes, my lord.
It is honestly our desire to dispose of everything. But honestly, I will not allow any ruling or judgment disturb me during holidays. Just 2 weeks to see my family after 3 months. And then for the next 3 months, I won't see them again. And you want me to carry judgment or ruling on my head? No.
My Lord, I'm very grateful, sir.
So what date? 21st January. Is 21st January okay for us?
My Lord, I'm checking already. My Lord,
it's okay. It's okay for us.
My Lord, it's not okay by my diary. And before your learned brother here, I court. Abukadi, just Abukadi.
Okay, give us another date. 29th January. What of 29th?
My
Yes,
Lord,
my Lord, it's okay.
My Lord is okay, sir. I don't know for my friend.
No, we're okay. We're okay.
Case adjourned to 29 January 2025 for motions.
Please, my Lord.
My Lord,
physical, please. Physical, please.
Okay,
I don't want this this Zoom experience again. It will be physical.
Please, my Lord.
My Lord, sir.
Yes.
There's no problem, my Lord. There's no problem. God will see us through. I don't.
Thank you very much.
Thank you, my Lord.
I mean, we never have problems.
Amen, sir. Thank you. You may not be there. Don't know who I am here.
Okay, that is all for today's Zoom hearing, and we shall all leave.